Can a court conduct a Sora hearing even if the defendant is incompetent? To find out, you have to read People v. Watts, but it's 43 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People v. Watts. The citation for this case is 2024 New York Slip Opinion 00926, published by the New York Court of Appeals on February 22nd of 2024. The issue in this case is whether a Sora court, a Sex Offender Registration Act court, can conduct a Sora hearing with an incapacitated defendant, or whether that constitutes a due process violation. I'll explain all that in a few moments. I think the background that's helpful to understand this case is that in a criminal case, if someone's facing a criminal case in New York, CPL, Criminal Procedural Law 730, says, which talks about the fitness to proceed, says that if there's an incapacitated person, if a person is incompetent to stand trial, then the case cannot proceed. You can't conduct a trial against an incompetent or incapacitated person. You have to put them into an institution and wait for them to become competent to stand trial. The other thing you have to know is that Sora, the Sex Offender Registration Act, provides for a hearing under Corrections Law 168D. It talks about the procedural rights, the obligations the court has, the DA has with respect to that hearing. There are a lot of protections built into that hearing, including the defendant has the right to notice, a written statement of what the people intend to prove, the right to appear, the right to be heard. The people have the burden of proof to prove by clear and convincing evidence. The sex offender level, if there's a dispute, the court must adjourn if the defendant needs records. There's subpoena power. There's a relevance bar to evidence. There's a right to sealing. There's a right to an attorney. There's a right to have an attorney appointed if you don't have the money for it. There's a right to appeal. And those are the rights that are inherent in a Sex Offender Registration Act hearing. What are the facts of this case? The facts are that in July of 2011, the defendant in this particular case knocked down a 66-year-old woman and attempted to rape her. When he was arrested, he explained that he was responding to voices in his head that told him that she was chosen as a victim for him. He was arrested and charged with various crimes, including sex abuse 1, which is a sex offense, and assault in the second degree. The criminal judge that was dealing with his case ordered a competency exam under CPL 730 I just talked about, and he was found to be incompetent to stand trial. He was not fit to proceed. He was placed in the care of the Office of Mental Health, where he stayed for 5 years. He was unfit for 5 years. He had a history of psychosis and schizophrenia. He had 6 more competency exams where he was found unfit. Ultimately, he had a 7th competency exam where he was found to be fit. And at that point, he pled guilty to sex abuse and assault 2. He was sentenced to 6 years and 10 years, 6 years jail, 10 years post-release supervision. But at that point, he had pled guilty to a sex offense. So he was scheduled for a Sora hearing. But at that point, his mental competency decompensated, right? He decompensated, became unfit again, basically incompetent. And at that point, when it went for the Sora hearing, his counsel at the hearing said, "Judge, you can't do this hearing. My client is incompetent." The judge adjourned it. At the next appearance, there was a conflict between the defendant had an Article 9 case that day, so the judge adjourned it again. Finally, at the next appearance, the defendant is present, but the lawyer says to the judge, he's still not competent. He doesn't know what's going on here. The judge says, then the defense counsel says, "You have to adjourn this case. I'm requesting that you adjourn the case." The judge says, "No, we're going to do the hearing." The judge conducts the hearing while the defendant is physically present, and he's adjudicated a level 2 sex offender. The defendant appeals, saying, "You shouldn't have done the hearing while my client was incompetent or incapacitated." The appellate division affirms the hearing decision and affirms what the trial court did. And here we go to the Court of Appeals, and this is an interesting case. If you're interested in this kind of area of law, read the decision, read the dissent, and watch the 45-minute oral argument here. Fascinating. Ultimately, the holding here is that because of the panoply, the holding here is that due process requires notice and an opportunity to be heard, and he got those things. But Sora is a civil, not a criminal proceeding. It's related to criminal proceedings, but it's not itself a criminal proceeding. And because it's not a criminal proceeding, it doesn't get all the safeguards that a criminal proceeding gets, including what would be CPL 730. So you don't have 730 rights under a Sora hearing. So they go through a 3-part test. They say to determine whether there should be an additional safeguard here with respect to like applying 730 to a Sora hearing. we're going to apply the Matthews versus Eldridge test. It's a 3-part test. You have to evaluate and consider the private interests that will be affected by this additional procedural safeguard, the risk of erroneous deprivation of the procedural safeguard, and the government and public's interest and the costs associated with it. They go through that analysis, and they say that basically, in sum, after analyzing all of this, because there are so many protections in place that I mentioned, the factors developed by the board, adversarial hearing, judge deciding it, entitled to a lawyer, advance notice, discovery, subpoena power, burden of proof, right to appeal, because of all the procedural safeguards already present, and there's no proof that having an additional safeguard of having him be competent would prevent erroneous risk level assessments. The holding here by the majority is that this is not going to be required, that incompetency does not preclude a Sora classification. A judge, in short, can conduct a Sora hearing even if the defendant is incompetent or incapacitated, essentially. But I would urge you to read the dissent here by Judge Rivera, joined by Judge Wilson, by Chief Judge Wilson, because they basically say all the rights that you just talked about, all the rights that are inherent in the Sora hearing are meaningless without the defendant being competent to understand and appreciate and participate in it. The right to counsel doesn't mean anything if the defendant can't participate. But once again, the holding is incompetency does not preclude a Sora hearing. And that's the case of People versus Watts. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.